Recently, the third panel of the Superior Court of Justice ordered the suspension of a policyholder's lawsuit against the insurer due to the existence of an ongoing arbitration proceeding between the policyholder and the insured. To discuss this topic with us, we have Thais Arza Monteiro, a partner at the law firm Mattos Filho. Today, we welcome Thais Arza Monteiro, partner in the Litigation and Arbitration, Insurance, Reinsurance and Private Pension, and Intellectual Property Practices at Mattos Filho. Thais, thank you for accepting our invitation. It's a pleasure for us to have you with us today.
Thank you, Carol. It's a pleasure for me. Thank you much for the invitation.
Not at all. Well, this is actually quite a very recent and relevant topic that has been discussed extensively. And it's important to note here that we haven't had access to the court decision, so we'll be discussing the topic based on the news that was published. But breaking it down into sections, I'd like us to start by talking about the regulation process when there is an ongoing arbitration proceeding. So, according to the reporting judge, as mentioned in the news article, prejudiciality is established when the outcome of one case depends on another, external and overriding case, which may result in the temporary suspension of the first case. In this way, one of the cases will move forward so that the main issue can be resolved, which will then influence how the subordinate issue is decided. In this case, the subordinate issue would be the regulation of the insurance claim initially, and the overriding issue would be the liability for contractual non-performance, which is being discussed in the arbitration proceedings. And so the first question that arises is this: since the arbitration procedure is confidential in practical terms, what practical effect can it have on the claims adjustment process, given that the evidence produced in the arbitration and the award itself are protected by confidentiality?
Perfect, Carol. Well, I think the rule to start with here, right? The rule of confidentiality applies to any arbitration procedure, right? So it doesn't really matter here whether we're talking about an arbitration procedure between the policyholder and the insured. It's a rule established by law. So everything that happens, evidence production, decisions, hearings that take place during the arbitration procedure, they are all subject to confidentiality, right? And I think the important point here is that the insurer does not participate in the arbitration procedure in which the breach of contract between the policyholder and the insured is being discussed. So in fact, it would be restricted from accessing the evidence, the decisions, everything that is done and produced within the arbitration procedure, right? In practice, what we see when this type of situation occurs, in which we might eventually have an arbitral award that is a prejudicial matter to a judicial process or to the regulation, which we'll talk a bit more about later, is that it is usually possible to request that the arbitral tribunal share those documents, the evidence, and the decisions that were produced within the scope of the arbitration process with the judicial action, right? I mentioned that there is a precedent here from the São Paulo court, which is already a bit old, probably about 4 or 5 years, in which exactly a similar situation occurred, right?
But still in the regulation process, not yet.
In this case, no. In this case, there was already a lawsuit, right, from the insured against the insurer. And one of the reasons for denying the indemnity payment was the use of inappropriate material during the construction, right? When the case reached the Court of Justice, then we can talk a bit more about these impacts on regulation, right? But when it reached the Court of Justice, there was then a request to notify the arbitral tribunal so that it would share everything that had been produced and decided within the scope of the arbitration in the judicial proceeding, right? Filed between the insured, yes, by the insured against the insurer. In this case, the request was granted. And then with a court decision, the arbitral tribunal can break this duty of confidentiality, right? So he must comply with the judge's decision, and then he shares the decision. But that's in a scenario where we already have a lawsuit. If we're in a claims adjustment scenario, then I see that we would face significant challenges in accessing this information, right? In that case, one possible route would be to file a suit for the production of evidence to request that the tribunal provide those documents. And then it would be a lawsuit just to obtain those documents, right? Or if there's goodwill, the insured and the principal, well, then they can share, always requesting authorization from the arbitral tribunal. So that's also an option, right? For the principal, for example, to go there and ask the arbitral tribunal and say, I need to share these documents for a claims adjustment or exactly. But what's important here is that
Sorry, Thais. So in that case, the principal would make the request within the arbitration proceedings.
the arbitral judge would then rule on that request after hearing the opposing party. Exactly. But would both parties have to agree would they have to agree, or could the tribunal say, no, even if the insured doesn't agree, I see that this is relevant? Yeah. There's an important point about confidentiality, which is that documents related, for example, to the contract or the construction schedule aren't confidential just because they're part of an arbitration.
Yes.
What is confidential in arbitration are the filings, everything that is produced within the arbitration itself. So, for example, the request for arbitration, initial statements, or a document that might be presented only there, which isn't really related, isn't the contract or documents from the contract's execution. Those are different. An expert report, for example, is protected. So everything that is produced during the arbitration is protected. So I think it's also important to make this distinction, right? Because in a claims adjustment, obviously, you'll have to provide the contract and some documents related to the execution of that contract, which is the subject of the insurance, right? So that's not protected by the confidentiality of arbitration, but what is protected are the actions taken within the arbitration.
Yes. Yeah. And thinking from this point of view, then, during the adjustment process, the insurer becomes aware of the ongoing arbitration proceedings, understands that there is a relevant connection between what is being discussed in the arbitration and what is being raised and investigated during the claims adjustment, and it seeks to suspend the deadline. What regulatory risk could it face? Because in principle, it would need a court decision to suspend the adjustment process. So what regulatory risk would it face by choosing to suspend the adjustment process due to an ongoing arbitration?
Okay, no, perfect. I think just one point here before getting into the details of the answer to the question. As you mentioned, Carol, we haven't had access to the ruling, but according to the news on the STJ, on the Justice Tribunal's website, and from the video of the judgment session that we were able to watch, apparently, the reporting minister understood that the regulation should take place after the conclusion of the arbitration proceedings. What we know is that in practice, this will be impossible to implement. Why is that? First, an arbitration proceeding of this nature. We're always talking about complex cases here, right? Engineering projects, cases that require significant and substantial technical discussion, right? An arbitration of this nature isn't resolved quickly, right? Because you'll need to gather evidence, hold hearings, and go through a lengthy process, right? So we're talking about sometimes 3 or 4 years just to reach a resolution in an arbitration proceeding like this. So I can't imagine that you would wait for the arbitration process to begin a claim adjustment, because usually the insured will already be having a dispute about non-compliance with the principal, and they'll notify the insurer, right? They'll let them know there's a claim or a potential claim happening, and the insurer will have the duty to start the adjustment process. So I think this is an important point that may have been a misstatement, since we didn't have access to the decision when it mentions that the adjustment will only start after the arbitration process, because I don't think that's possible in practice, right? Especially considering this timeline that I brought up here. In any case, if the insurer is notified, they start the adjustment process, right? And here I think it would also be good for us to draw a parallel with the new law, which isn't in effect yet, right? It will only apply to future adjustments, but I think it's already worth making a comparison here as well. So during the adjustment process, the insurer finds out that there's already an arbitration proceeding, and whatever is being discussed in the arbitration will impact the adjustment, okay? And this is another important distinction, because the arbitration proceeding doesn't necessarily, or not always, impact the insurance dispute, since in the insurance dispute we discuss matters that apply only to the relationship between the insured and the insurer. So, for example, if there was an omission of information or prescription, all of that is not tied to a discussion in the arbitration proceeding. So it may happen that the adjustment process has already started. There is an arbitration proceeding, but the insurer looks at it and says, no, this has nothing to do with my insurance dispute here. I'm going to proceed with the adjustment and it's irrelevant. But it can also happen that there is in fact a cause, right? A subordinate and a superordinate issue there that have a direct connection. Yeah, in this case, right, I don't see how the insurer, even from the perspective of the new law, right, and remembering that now the adjustment period is a peremptory deadline. So If you do not observe the established deadline, you effectively lose the inherent right to comment on that particular coverage. The indemnity, the comprehensive coverage, is considered fully accepted. Is that correct? So I don't see how the insurer, on its own initiative, could just say, I'm going to suspend this here because I'll need the decision from the arbitration proceedings, right? So the way forward is either to reach a mutual agreement, right? To seek an arrangement with the insured to suspend, to say, let's suspend this adjustment process. I think that under the new law, this could present some difficulties because, as I mentioned, it's a forfeiture period. And the forfeiture period, is not like the statute of limitations. You don't have suspension, you don't interrupt it. Or the alternative is to go to court to ask the judge, to say, look, grant me an injunction so that I can refrain from concluding the adjustment process right until there is a final decision in the arbitration proceedings. But I think that if we apply this reasoning, it has very significant impacts for the insurer. How is it going to deal with this situation, right? Knowing that it can't just say on its own, I'm going to suspend the adjustment process.
We're talking here about the relationship, a guarantee provided to a private policyholder. Yes, there would also be the possibility, already from the perspective of the new law, that within the risk questionnaire, the insurer could seek a prior agreement from the principal and the insured, so that when the main contract includes a provision stating that disputes under that contract will be referred to arbitration, the risk questionnaire would already seek the parties' agreement to this. And if, in the event that there is a dispute in the main contract that goes to arbitration, the insurer would have access to the evidence produced and the arbitral award, already anticipating this future scenario in which the insurer would need to act, right? If it sees a relevance between what is being discussed in arbitration and the claims adjustment process. And also, eventually, since the insurer now has to proactively prepare a list of documents to be requested during the claims adjustment process. It should also anticipate and include an important item stating clearly, look, if there is an arbitration proceeding, all of the evidence and materials that are produced, as well as the final award itself, should be readily shared and made available.
This could be one way, right? Because today the deadline, starting from the new law, not today, but from when the new law comes into effect, the claims adjustment period will begin from the delivery of all the information and documents specified in the policy, right? So you'll have the list. From the moment we make this mandatory, it could be a good solution because then, right, you can say, look, as long as there's no decision, my claims adjustment period hasn't started yet. I just want to make one observation because, as I said, right, an arbitration proceeding can take 3-4 years. And then eventually starting to adjust a claim that happened today, 3 or 4 years from now, can sometimes be detrimental in terms of gathering evidence, right? Because if a claim happened today and I start adjusting it today, it's easier. The documents are there. Sometimes the construction is still ongoing. It's not finished yet. So you can still gather some information from the moment
the financial situation of the principal hasn't deteriorated over time.
Exactly. So there's this issue of timing that I think always needs to be considered.
Of course, but if the insurer includes it in the list of documents and puts this requirement in the risk questionnaire and includes it in the list of documents to be submitted for the claims adjustment process, it would be reserving its right to demand it, but it could also, during the adjustment process, eventually choose to waive the requirement for that document. And then it could
eventually receive the notice of claim without the copy of the arbitration because the arbitration has just started, right? There isn't an award yet. It might eventually say, no, I think what I've received here is sufficient. I'll process this claim.
Start the process?
Yes, it can start. Exactly. But then it could also, right, as a counterpoint, like you mentioned, use this as an argument to say, I'm not going to start because I haven't received all the documentation I need here to process this claim.
Interesting. And by doing that, would it avoid having to file a lawsuit and seek an injunction to possibly suspend a deadline because under the new law, it wouldn't have started yet?
Yes, but I think it's always important to emphasize that each case needs to be analyzed individually, right? Because it could be...
We're talking about hypotheses here, right? And possibilities.
Yeah, exactly. Because you might have a case where it's not in your interest, right? Like we mentioned. Oh, the arbitration list is there, but as the insurer, I think it's better to settle this claim now. And I don't depend on the discussion that's going to happen. Because remember, as I mentioned at the beginning, the insurer does not participate in the arbitration proceedings, so they won't be involved in the production of evidence. They won't be able to request a document to provide evidence or evidence on a specific point that is relevant to them. So I think each case needs to be analyzed individually to determine what the best strategy is in light of the reported claim.
Yes, and as you mentioned, the insurer can eventually choose not to access all the documentation related to the arbitration if it's not relevant to the arguments it has to take a position regarding the claim. To deny or provide coverage, exactly. Yeah, so I think we've already covered the regulatory risk, and we've also talked a bit about whether or not the insurer is required to suspend the claims adjustment process, right? There's an important point here regarding the relevance of what's being discussed in the arbitration process and also strategy, right? As you mentioned, there isn't a standard formula for every case. Each case needs to be analyzed individually, and in some situations, settling the claim more quickly can actually be beneficial, even because of the right of recourse and being able to pursue reimbursement from the principal.
Exactly.
So regarding the claims adjustment process, I think we've covered all the points. This might not necessarily be something new given what we've been discussing here, but I think it's always good to mention when some action by the principal is also observed, because we've talked a lot from the insurer's perspective, right, about what the insurer could do if necessary and appropriate to make use of what is produced in the arbitration context for claims adjustment. And what about the principal? What exactly could they do if, for instance, they are absolutely certain and very confidently believe that they were not in any way responsible for the claim, so that they can effectively intervene in the entire adjustment process, perhaps right at the very beginning of the comprehensive adjustment carried out by the insurer?
Perfect. And I actually think I have some practical cases to share, right? I think the principal can, for example, file for arbitration and request an injunction, right? So that, for example, if the insurer is still in the process of adjusting the claim, they can be ordered to refrain from concluding the adjustment until there is an arbitration proceeding, right? But for that, they'll depend on getting an injunction, right? Granting them this right. And then I think the insurer is also in a more comfortable position since they won't have to adjust the claim because there's a decision preventing them from concluding the adjustment, right? The counterpoint here, again, is if the insurer wants to proceed with the adjustment, right? So anyway, due to time constraints, as you very well mentioned, Carol, there's the issue of the principal's financial situation deteriorating and then later seeking recourse. Yes, or they might eventually request an injunction, which I've seen happen in practice, where the court orders, insurer, complete your adjustment process. If you determine that there is coverage that you are going to pay, don't pay the insured directly. Make a deposit instead. Exactly. So you make a court deposit if it's in the judiciary or in an arbitration proceeding. You put it in an escrow account. The money stays there. And then once it's resolved, whether there was performance or not, right? And then the arbitral tribunal will also have to rule on this point, right?
And by making the court deposit, do they have the right? Can they exercise the right of recourse?
Yeah, this is another very relevant point because here I see that we would have some difficulties, right? Because the right of recourse arises with the payment, right? So from the insurer's point of view, they're no longer obligated, right? As far as their duty goes, they've made the payment. So in my opinion, at that point, even if it's just a deposit, their right to claim from the principal would already arise. But there could also be a principal who files for an injunction, right? In the sense of, look, order the insurer to make the deposit and not to exercise the right of recourse until there's a resolution, okay? But in my opinion, from the moment the deposit is made, the insurer's right arises because they fulfilled their duty to settle and pay.
Yes. And eventually, if the insurer has made the deposit and having filed the recourse action against the principal and the principal has paid the insurer, if the principal is successful in their action against the insured, would the amount deposited in court go back to the insurer or to the principal?
Yeah, I think if the insurer has already exercised the right of recourse, then the amount should go to the principal, right? If not,
they attach this recourse to the case and then transfer the right over that deposited amount.
Exactly. Or else release it to the insurer, right?
Yes. I see that in this case. It would be easier.
Yeah.
It's complicated, isn't it? There's always another aspect to consider.
Yeah, exactly. There are always further developments, right? Yeah.
That's the beauty of the product. Well, so we've talked a lot about the claims adjustment process. So when the insurer, well, we were discussing a scenario where the insurer became aware of the ongoing arbitration proceedings during the claims adjustment process. There's one more point. Yeah, before we move on. At first, there is no obligation for the principal or the insured to notify the insurer about the existence of an arbitration proceeding.
Yes.
Maybe it would be interesting for the insurer to include this in the risk questionnaire or in the claims adjustment process so that they are informed and made aware if there is an ongoing arbitration dispute.
I think it's important, but my point is that sometimes when the adjustment process begins, the arbitration proceeding doesn't exist yet, right? So maybe it's something to ask during the adjustment process, right? We have those two deadlines, right? For suspension, where you can request documents with justification, but I also think it's an important point to include, right? If there is any kind of dispute, whether judicial or arbitral, between the principal and the insured.
Yes, yeah, and in the specific case of the adjustment, if it's temporarily suspended due to
because of an injunction.
Right, because of an injunction, is the maximum period for suspending the adjustment determined, or is it set in the injunction itself?
So it will really be up to the judge, for example. The right thing would be, if the judge grants the injunction to suspend, it should last until the end of the arbitration process.
Until the end, yes. Right, and this is an important point that differs when the insurer becomes aware of the ongoing arbitration process, after it has already adjusted the claim, possibly denied the claim, and then the insured files a lawsuit against the insurer challenging and contesting the insurer's decision. Yes, in this sense, over the course of this lawsuit, if the insurer then becomes aware of the existence of an ongoing arbitration proceeding, the suspension, the possible suspension, right? And I also believe that there is relevance between what is being discussed in the arbitration and the arguments used to deny the claim, whether it could then, be suspended, right? And according to the Civil Procedure Code, what would be the maximum period for this suspension?
Yes, as a rule in the Civil Procedure Code, the suspension of a case, regardless of the type of case, whether it's suspended due to another lawsuit or an arbitration proceeding, has a maximum period of 1 year, right? But this period is often made more flexible by the courts, especially when it's clear that the case won't be resolved within a year and it's necessary to wait for another case to be settled in order to conclude the one that's currently suspended. So I think that's the first point. Normally it's 1 year, but there can sometimes be some flexibility, right? Yeah, and I think this brings us back to what we discussed about suspension, right? In a scenario where the insurer is already facing a lawsuit filed by the insured, I think it really depends on the specific case. It will depend on the analysis of the grounds for the denial, the reasons being discussed in the arbitration proceedings to determine whether it's appropriate to request a suspension or not. Because again, right, the insurer doesn't take part in the evidence production during the arbitration proceedings, which can often be very detrimental, right? On the other hand, the insurer also doesn't have all the information related to that guaranteed contract because, for example, they weren't at the construction site following what was happening there on a daily basis. So many times it can be beneficial to use evidence in which the principal, the one who was actually providing the service, has much more information and much more knowledge. So maybe the evidence there will have, greater accuracy, more detail, a wider range of documents than evidence that would be just between the insurer and the insured. But then my view is that it has to be evaluated on a case-by-case basis. I don't think we can apply this understanding from the STJ. First, I think an important point here is that this is not a binding decision, okay? It's a decision that was handed down in a special appeal for a specific case. So we can't use this decision as if now all insurance lawsuits will be suspended because of arbitration. No, I think it has to be an analysis, as we say, case by case to really understand the facts, what the actual relationship is, whether there is this prejudicial connection, and whether, from the perspective of the proceedings in that case, it makes sense to suspend it or not.
That's clear. Well, so we've already talked about the claims adjustment, right? When the insurer becomes aware of an ongoing arbitration, and also about when the process is already further along and there is possibly already a denial, at which point the insured has filed a lawsuit against the insurer. And then at that moment, the insurer becomes aware of an ongoing arbitration proceeding. And now I'd like to talk about a third section within this same topic, which would be, I'll start by quoting part of the news here, and then we can gradually explore it together, right? So quoting the news that was published, citing case law from the STJ, the minister added that there is a consolidated understanding that the subrogated insurer must submit to the arbitration clause provided in the main contract signed by the insured or policyholder, so that in these cases, the competence of the arbitral tribunal prevails for the examination and judgment of the recourse claim. The prior knowledge of the insurer, and then quoting here, the prior knowledge of the insurer regarding the arbitration clause agreed upon in the main contract that is the subject of the surety insurance gives rise to its submission to the arbitral jurisdiction, since it is part of the risk unit covered by the policy itself. And then, breaking it down step by step, right? Let's digest what's written here little by little, right? Yeah, little by little. So the first point for us to address would be regarding this subrogation, right? The insurer, again, we didn't have access to the full decision, but from what we understand, there was a denial of the claim, and the insured challenged the insurer in court regarding that denial. So there wasn't a payment of indemnity by the insurer, right? Which would be the precise moment in time when there would then be
subrogation.
Exactly. If you could explain a little about this STJ case law, just so we can clarify when and how the insurer would be subrogated to the arbitration clause provided in the main contract.
Yes, absolutely. Yeah, I think the point here is that we weren't able to get access. So there's this mention in the news, but we can't really know what the context is of this subrogation discussion in this case, especially since the case is under seal, right? Yeah, but what we do have, right, is the recent case law from the STJ regarding subrogation. They have understood that in this case, then it wouldn't be the situation we're dealing with here, okay? So the insurer compensated the insured, and then it subrogates into the rights of that insured against the party at fault, in this case, the principal, okay? Yeah, so, and this is where our interpretation comes in, right? And the way the market has been operating is that in this subrogation, the procedural jurisdiction rules established between the insured, the insurer, and the principal prevail, which as a rule do not include an arbitration clause. So this recourse takes place in the judiciary. It's the insurer suing the principal in court. However, recently the STJ has adopted the understanding that in subrogation, both the substantive rights, meaning the right to collect that credit, and the procedural prerogatives are transferred. So the STJ has come to understand that this recourse must also follow the procedures set out in the guaranteed contract, that is the arbitration clause, okay? So that's the STJ's position. Now, drawing a parallel with this case, I couldn't quite understand how they want to apply subrogation here, because there is no subrogation in this situation. Yeah, but I was mentioning earlier to you, Carol, that we recently had a case at the Federal Regional Court of the Second Region, which involved a contract, a surety insurance policy with a public entity, right? In this case, the insurer filed a lawsuit against the public entity, which is the insured party. So we're not talking about recourse here, right? Which is similar to this case here that was judged by the STJ. And the discussion was about whether the insurance indemnity was actually owed to that public entity, which is the insured party. And the TRF of the second region, the Federal Court of Appeals in the first and second instances in Rio de Janeiro, understood that this discussion between insurer and insured, not only in the case of recourse, but regarding the indemnity itself, would also be subject to the arbitration clause, because the reasoning behind this decision is very recent. It's not confidential, so it's easy to find it on the court's website. Yes, the reasoning of the decision is that since the insurer will end up discussing the guaranteed contract then, right? If there was a breach or not, it would also be subject to the arbitration clause provided in that contract. So drawing a parallel here, maybe that's what happened, that in some cases, in a way they wanted to discuss it. It's hard to say. But yeah, if that had been the case, the proper course wouldn't have been to suspend the proceedings due to a prejudicial issue, but rather to dismiss the case because of the existence of an arbitration clause. So I mean, the news is there, right? It's at the end of the article as a separate section, but I think it's important to make this distinction that here, right, subrogation is not, we're not talking about subrogation in this case, right? So it wasn't very clear what the reasoning was, for mentioning subrogation in this precedent. But we have these two lines of thought, right? So today, the STJ is moving towards a subrogation of the insurer in the arbitration clause in the case of return. And there is this isolated precedent from the TRF of the second region, which also understood that a discussion between the insurer and the insured should take place in arbitration.
And to avoid this understanding, is there in a policy aimed at the private insured, is there instrument that the insurer can adopt to avoid being bound to the contract, the adhesion to the arbitration scope for discussions? Is it agreed between the insured and the policyholder of the main contract?
Yeah, I see the main solution as the counter guarantee, right? Because when exercising a right based on the counter guarantee contract, it's a right the insurer has directly against its client, right? Who was the policyholder of the insurance. So I think that through the counter guarantee, that's going to be the way to try to get out of this decision, which in my view is mistaken, but it's what's been prevailing in the STJ, so that we can, especially since the counter guarantee is an enforceable instrument, right? Yeah, it was recently included in the Civil Procedure Code, right? In the list of extrajudicial enforceable instruments. So the idea is to try, through the counter guarantee contract, to make the chosen jurisdiction clause prevail, right? The one that's selected between the insurer and the principal.
Yeah, but that would only prevent the recourse of the insurer against the principal, and not the case you're bringing up, which was actually a dispute between the insurer and the insured, which wasn't related to subrogation, but was also directed to arbitration.
Yeah, maybe in this case, just thinking out loud here, right? I haven't seen any real life cases yet, but maybe in the case of a private company, you could explicitly state there that, no, I'm not going to, right? The parties aren't subject. There won't be, right? Try to make the instrument maybe a bit clearer, Include it in the policy, or even create a separate document stating that any claim by the insured is waived, that the arbitration clause will not be observed, so we can avoid this kind of discussion. But this precedent from the Federal Regional Court is quite isolated, right? It's the only one so far. Yeah, obviously this will be brought up for discussion at the Superior Court of Justice, but it's concerning if they start to interpret that even disputes between the insured and the insurer must be resolved through arbitration.
So regarding the insurer's submission to the arbitration clause to proceed in the arbitral forum as provided in the main contract, we've covered a few different situations. So one situation is when the insurer pays the indemnity, is subrogated to the insured's rights against the principal debtor. And then, according to the Superior Court of Justice's case law, the insurer takes the insured's place in the main contract and automatically is subject to the arbitration clause and must pursue the claim against the principal debtor in this recourse action through arbitration. In this context, the counter guarantee contract would come into play, because in this recourse action, the insurer would make use of this other instrument, right, which was signed between the parties. From this perspective, and as you very well pointed out, right, almost 2 years ago, right, in October 2023, the counter guarantee contract was added to the list of documents, right, of extrajudicial enforceable titles provided for in the Civil Procedure Code. And the fundamental question is, when this specific subjection, this complete and total submission to the binding arbitration clause, is formally included within a legal agreement, how precisely does that significant inclusion ultimately affect the overall enforceability and legal validity of the title itself?
It's a pretty complex issue, Carol, because, well, there are a few points we need to consider, right? First, in the counter guarantee, you might have third parties who are the guarantors and they're not part of the main contract, okay? And so we already have a first issue. How do you subject these third parties to arbitration when they weren't part of the guaranteed contract, right? So that's already the first difficulty, which applies to any type of arbitration, because you can't bring a party into an arbitration proceeding if they haven't agreed to that clause, okay? So eventually, I think this will have to be a strategic discussion, right? Or you could initiate arbitration against the borrower and enforce the counter guarantee. But then you'd basically have two proceedings, right? Both pursuing the same debt with the same discussion, or you could just choose one route. For example, you could enforce the counter guarantee contract, right? Because there's this difficulty, which I think is also a key point that the Superior Court of Justice hasn't really addressed in detail yet, which is, how do you submit a third-party guarantor to arbitration if they haven't agreed to it, right?
Yes.
Because I think that so far, the precedents that have been decided involved situations where there was some confusion, right? So the borrower was also part of the counter guarantee. So in the end, you ended up having everyone subject to the arbitration clause, but this is a point that still hasn't been discussed or analyzed, because how are you going to take a third party and subject them to arbitration when they haven't agreed to the clause, right? So eventually, yeah, I think we're going to have some relevant procedural discussions here, right? Or you follow these parallel paths, but then I think there's a problem. You'd be collecting the same debt through two different channels, so how do you handle that, right? Or eventually, you only enforce the counter guarantee, right? And only pursue the counter guarantee in court. Then I think it really depends on a case-by-case analysis. So you can eventually see who the guarantor is, what the solvency of that company is.
Yeah, if you eventually open both avenues, you run the risk of the borrower seeking to suspend the enforcement due to the existence.
They can, exactly. So you also have all these, right?
All things considered.
And there's another issue as well, which is that you'll be subject to two sets of core costs, right? Because, okay, in arbitration, you might agree and not have core costs, not have to pay attorney's fees, but in enforcement, you will, right? So I think there are issues here as well. And that's the point, right? It's a mark. This product has a lot of details, right? It's a complex relationship if we look at it, right? Everything we're discussing here about counter guarantee contracts, the insured parties' actions, recourse, and I think the judiciary, to some extent, in some cases, isn't able to see all the complexity and the impact of these decisions on a product like this.
Yes, and eventually I think you brought it up, right? Given if the decisions are based on a case, eventually they cannot be generalized, because in the case that you have a third-party guarantor, you would really be prevented from following that path.
Exactly.
Interesting. Well, I think we managed to address here then the STJ's jurisprudence as it happened in the past. The citation, again, it's not clear because we had access to the appellate decision, but at first there was no indemnity. The claim was denied, so there wouldn't be this path, right, of submission to the arbitration clause at first. You brought up another case, right, to enrich our discussion, in which there was a submission to the arbitration clause also without indemnity being paid. That is, it wasn't about subrogation of rights, but there's still the possibility that it could be reversed.
That's right. Exactly.
That's great. Thais, we've covered this topic, which is quite recent, from several great angles. I think it was very enriching. I hope this will make a relevant contribution for insurers in any case, to help them think about their strategies, both in terms of defense and in designing for the policyholder. Also, to consider the possibilities when a situation arises when they're subject to a dispute with the insured, and for the insured as well to understand all the complexity involved in claims adjustment, and also the possibilities of seeking arbitration or taking the matter to court.
Yes.
Thank you very much, Thais. It was very insightful. I'll definitely invite you again next time.
Thank you so much, Carol, and it was a pleasure to be here with you today.
Thank you. Today we had Thais Arza Monteiro, partner in the Litigation and Arbitration, Insurance, Reinsurance and Private Pension, and Intellectual Property Practices at Mattos Filho law firm. She has experience in complex cases, working in courts and arbitrations involving major risks, public administration, and judicial recovery. She holds a master's degree in procedural law from Université Paris Sud in France and a bachelor's degree in law from Mackenzie. She is also the vice leader of the legal committee of the France-Brazil Chamber of Commerce and is recognized by specialized publications such as Análise Advocacia, Benchmark Litigation, and Export Guides. Thais is a reference when it comes to law and innovation.